Alrighty, it's noon, so we'll get started. Welcome everybody who's watching in the Zoom webinar and those who are watching via Facebook Live. Throughout the event, please ask questions, and if you are in the webinar, you can do that through the chat feature or the Q&A feature. And if you're on Facebook Live, you can type questions into the comments. And Richard is ready. So type them as soon as you have them ready, and I'll make sure to ask them for you. So today I'd like to start with a little land acknowledgement. Indigenous peoples have lived in this region since time immemorial. Wenatchee River Institute today is located on the ancestral homelands of the Psquosa, the Psquosa or Wenatchee band. The Wenatchee River Institute offers this land acknowledgement as a step in honoring the original stewards of this land and to call for further learning and action. So thank you, Richard, for participating in this presentation today and for helping us and our greater community learn more about those ancestral, or excuse me, the original stewards of this land, the Psquosa people. So I'm Rachel Bishop. I'm the Community Programs Manager at Wenatchee River Institute, and we are a nonprofit in Leavenworth, Washington, and our mission is to connect people, communities, and the natural world. And today our programs look very different than normal. Pretty much everything is virtual. Our youth programs are virtual and our community programs are virtual. For community programs, we look like this. We're doing virtual presentations in Zoom webinar and Facebook Live, and we're also hosting virtual workshops and virtual classes and virtual series through Zoom as well. And our youth programs are, we are hosting virtual field trips with teachers in North Central Washington. So we are partnering with the teachers to find a time that works best for them and their students. And then we meet with their students via Zoom and teach them something related to environmental science with as much hands-on education as we can in the virtual environment. And we are also working with the Wenatchee School District after school program, who we've worked with pre-COVID and on a virtual atmosphere right now. We are hopeful to have some opportunity to do some in-person, really small groups, social distanced activities. And just as a side note, I'm getting a note that my internet connection is a little unstable, and I'm sorry if that is the case, but bear with me as we navigate our virtual atmosphere. Okay, and so I just have a few upcoming community programs I wanted to mention for folks if y'all are interested. So we have a virtual tracking series that's coming starting in February. It's 3 separate classes, one in February, one in March, and one in April. And it's an introductory series to wildlife tracking with Marcus Rainerson, who is with the Wilderness Awareness School in Duvall, Washington, and is also a tracking evaluator. You can sign up for one of those classes or the whole series, and there's much more information on our website about what each class will be talking about. And on February 17th, we have a virtual presentation with Peter Marbach, who's the photographer for the book called Healing the Big River, Salmon Dreams and the Columbia River Treaty. And then on March 18th, we have another virtual presentation, The Woman Behind the Cosmic Crisp Apple. So if you're interested in learning how that apple was created, tune in. Introduce our fabulous speaker for today. Richard Hart provides historical, ethno-historical, and environmental historical services and expert testimony for Native American tribes. The former executive director of the Institute of the North American West, he has organized a number of influential conferences, authored, edited 11 books, published more than 50 articles and essays, and presented more than 50 professional papers here and abroad. He has testified before Congress on numerous occasions and served as an expert witness for Native American tribes, the United States Department of Justice, and for states. He has received a number of distinctions and awards, including the 2012 Washington State Peace and Friendship Award with Jim Boyd. His papers form a special collection at the University of Utah's Marriott Library. So once again, Richard, thank you so much for joining us today, and I'll turn it over to you.
Thank you, Rachel. Thank you very much. And hello to everyone that's watching. So what I'm going to talk about today is the Wenatchee tribe's history and their litigation that led to their fishing rights near Leavenworth. So the Wenatchee tribe had a subsistence pattern that included fishing, hunting, and gathering and digging roots. Probably the most important source of subsistence for them was what was called the Wenatchee fishery. And that was the area located at the forks of the Wenatchee River and Icicle Creek. And every year when the species of salmon made their runs, there were 3 species in the old days: coho, chinook, and sockeye. And and many other tribal members from other tribes would join them, so that there could be camped along the forks there, from the forks and upstream on the Icicle, as many as 3,000 or 4,000 people camped. It was Wenatchee territory, but all of their neighboring visitors were welcomed. However, a salmon chief determined where people could camp, so there was a priority for the best fishing places that were handed out by the salmon chief. And then I should mention demography. One of the questions that comes up is how many Wenatchis were there? And we should keep in mind that beginning in the late 18th century, in the 1775 to 1800, there were a series of pandemics that Columbia region. And amazingly, it is said to have a population of all of the tribes on the Columbia in this area. So in pre-contact times, the population may have been 3,000 or more. After contact, the population was probably cut down to 300 or 400. And it's interesting, and we should keep in mind that the first non-Indian visitors to their territories, so the first Europeans that wrote about them, were seeing a population that had been reduced by at least 75%. And this had a huge impact on their subsistence activities. For instance, most hunting of big game, deer and elk and other big game, would have been done communally with a large group of people going out together, and they would build drive lanes, and they could drive a herd of deer into a central point where 2 or 3 hunters with bows and arrows could dispatch enough deer to provide meat for a lot of people for a long period of time. After population reduction, you couldn't do a lot of the communal activities that had been done before, and many of the specialized tasks were lost. So, for instance, guns became exceptionally valuable to the Wenatchee and to other tribes in the area, because one person could go hunting with a gun. And so the Hudson's Bay Company and the other trapping companies that came and encountered the Wenatchis and had trading relationships with them had goods that were really important to them. I think later on I'll show a slide that shows on the same slide, it's a transition period. You can see the mat lodges that were made with tule mats, mainly made by women, sewed together, a very time consuming activity. And there were series of mats, 2 or 3 layers on the outside and a couple of layers on the inside on the floor. And of course, one of the items that became really valuable to the tribes was canvas, because you could make a canvas lodge or a canvas teepee and move it much easier than you could a mat lodge, and it was more durable. So with that in mind, let me begin talking a little bit about why we have treaties. When the United States was first formed, even before the Constitution, some of the first things that were done by the Continental Congress were to admit that the native population of North America had some kind of rights to the land that they occupied and used, and the founding fathers, as they're called, said that they were not equal to the same kind of rights that white people would have. They were not true title, but they were it was Aboriginal title, which is basically a use right. But and this was supported by the Supreme Court of the United States and is firm law. Importantly, the United States decided that before non-Indians could settle an area and could survey it and for instance take out homesteads, Aboriginal title to the area had to be extinguished. And there were only 2 ways that Aboriginal title could be extinguished. One was by warfare, by conquest, and the other was by agreement or treaty. So that was the reason for treaties. The principal reason, Congress quickly determined that it was cheaper to do treaties than it was to fight wars with the tribes. And so as the United States moved west across North America and through different tribes' territory, and oftentimes pushing tribes ahead of them so that there were conflicts between tribes that were a tribe may have been pushed into somebody else's territory. As the United States moved west, it tried to conduct treaties with all of the tribes in order to extinguish Aboriginal title and allow non-Indian settlement of the area. So importantly, until 1846, this area was not completely clear who had which European power or which power had rights to this area. The United States claimed it, Russia claimed a portion of the area, and Great Britain claimed a portion of the area. And in 1846, there was what was called the Treaty of Oregon, which determined that the 49th parallel would be the main international boundary between Great Britain's possessions and the United States. And so it was not until 1846 that the United States began to make claims to this area, to the Wenatchis, the Psquosa area. Wenatchee, by the way, is a term that was used by the Yakima for the Psquosa, but the non-Indians, the whites, came in contact with the Yakima before they came in contact with the Psquosa, and so they began calling the people the Wenatchee, using the Yakima term. Wenatchis today don't seem to mind being called Wenatchis. They would prefer Psquosa because that is the term in their own language. So the first governor of the territory of Washington following the Treaty of 1846 was a person named Isaac I. Stevens. And Stevens was very ambitious, and he received instructions from the Commissioner of Indian Affairs and from his superiors in Washington, D.C., indicating to him that his first priority as governor of the territory, was to see if he could extinguish Aboriginal title of all of the tribes in the territory. And he set out, initially, he thought he could move all of the tribes onto one big reservation, and it would be on the east side of the Cascades, somewhere over here. And he set out to do a few treaties on the coast first, and his plans didn't work out very well. The tribes, there were two problems. The tribes demanded a portion of their Aboriginal territory to be part of their reserves. Most of them were willing to receive some kind of payment to extinguish title to a large portion of their territory. They didn't really, most of them didn't understand the idea of ownership and that they had really use rights. And sometimes some tribes uh, had conflict with them, and with those tribes, they would protect their boundaries. But lots of neighboring tribes oftentimes were great friends, and so there were uh, areas where numerous tribes used the same territory. In 1855, Stevens he finished a few treaties on the west side along the coast, and he had determined that that it was impossible to get the tribes to take a reservation if it wasn't part of their Aboriginal territory. So by the time he got onto the east side of the Cascades and was trying to set up treaties over here, he had determined that tribes would have to have a portion of their territory in order to give up Aboriginal rights, in order to extinguish Aboriginal title. He also figured out and learned that they required some kind of pay. The second problem that he had and the United States had is they didn't want to pay to support the Indians after their Aboriginal title was extinguished. And that meant that it was advantageous to leave them with a portion of their Aboriginal territory, a small portion, and give them hunting and fishing rights throughout their whole territory so that the United States didn't have to pay for their subsistence. And elsewhere, especially in the Southwest, tribes had given up large Aboriginal territories, and then they had no way to feed themselves, and so the United States had to spend the money, oftentimes in corrupt ways, to feed the tribal people and keep a large number of them alive anyway. So when he met in Walla Walla to set out treaties with all, he thought he was going to do treaties with everybody on the east side of the Cascades, and that didn't work out completely as he planned either. He ended up doing three treaties, one with the Umatilla, one with the Nez Perce, and one called the Yakima Treaty, which was actually, I think, 13 separate tribes were named in that treaty. And it's worth taking a minute here and talking about the treaty council. Another thing that Stevens did and the United States did, by the time they got out here, they had learned that they didn't want to have 20 different leaders that they had to deal with. So they would appoint somebody as head chief. And at the Walla Walla council meeting, they appointed a man named Kamiakin as head chief of the tribes for all the 13 tribes that were going to be represented in the Yakima Treaty. And Kamiakin was Yakima and Palouse. I think he regarded himself mainly as Palouse. There are a couple of good books out now about Kamiakin. And he did not want to be the leader. He didn't want to represent people. He didn't think he should be representing people. A lot of the people that the United States was forcing him to represent. And in fact, there was a River at the Treaty Council, and he said when they signed it and through his lips and blood was coming. After the treaty negotiations, Kamiakin returned to his home territory in the Palouse country and refused to have any relationship with the United States. They sent wagon loads of blankets and other goods to try and give him, and he always refused, saying, I might be poor, but I don't need to take anything from you. So with that in mind, there was the Yakima Treaty, and Kamiakin was the lead signer. There was at least one Psquosa Wenatchee person there that represented the Wenatchee tribe, the Psquosa, and that was a man named Tecolican. And the Yakima said that the Yakima were willing to sign the treaty, and the other tribes and the other signers were, the other representatives of tribes were willing to sign. But Kamiakin, as the Treaty Council got close to a signing point, Kamiakin said the Psquosa should have their own reservation. They shouldn't have to come to the Yakima reservation, and it should include the Wenatchee fishery, the forks of Icicle Creek and the Wenatchee River. And the Article 10 of the treaty, the Yakima Treaty of 1855, stated that the Wenatchee, the Psquosa, were supposed to have a reservation at the forks of the Yakima, at the forks of the Wenatchee River and the Icicle River. And it was supposed to be 6 miles by 6 miles, 6 miles square, so 36 square miles. And so that treaty was signed, and it was eventually ratified by Congress. So that's a ratified treaty. So that brings us up to, and let me just stop here, and I want to show you quickly the map that was done. Let's see if I can do this right. This is the map that was done by the Stevens Group. And can you see, I hope you can see my cursor. This is marked as the area, this is the confluence of the Wenatchee River and the Icicle Creek, or Icicle River as they called it. And this black area was the area they marked out to be the reservation of the Psquosa. And as you can see, there's a very large area of traditional land of several tribes that was supposedly ceded by the tribes in return for hunting and fishing rights in the whole territory, in the Aboriginal territory of the various tribes, as well as the permanent rights to their own reservation. Now, all of the tribes that came from all the other areas within the area to go to the Yakima reservation, and you all probably know where that is. Were supposed to stay where they lived and go to the Psquosa reservation. So, unfortunately, the United States failed in its responsibility to actually survey that reservation for the Psquosa and to remove it from the public domain. Although the Wenatchis continued to live where they were and assumed that their reservation had been established, it had not actually been reserved for them. And so the United States had failed in its obligation. They continued to be friends with the non-Indians, with the white people, and oftentimes protected white people from other tribes that were at war with the whites, with the United States. And there are several instances of Wenatchis protecting white groups as they tried to travel up the Columbia and up toward the Okanagan rivers. And as a result, a number of military officers met with the tribe in the next 3 or 4 years after 1855 and promised to enlarge their reservation to 8 miles square, or 64 square miles. Unfortunately, this agreement, although one military general actually marked it out on the ground, and it seems to have looked something like what was on that map that I just showed you, but it was never ratified by Congress. However, the 1855 treaty was ratified and went into effect, the highest law in the land by the United States that the United States could make. There was a long period where the Wenatchis, the Psquosa, and the other tribes in the region were relatively unmolested. The Psquosa lived where they thought they had a reservation and stayed living in the villages that they had along the Wenatchee River. Although there may have been 3,000 or 4,000 people in pre-contact times, by the time Europeans arrived in the area, they were reduced to maybe 300 or 400. So there was a great depopulation, a dramatic depopulation. And another impact of that was that tribes which had been endogamous, that is, they married only within their group, they chose mates within their own group, became exogamous. They often had very strict rules about, for instance, you shouldn't marry anyone who's closer than his third cousin, whatever a third cousin is. I'm not that great on genealogy. But they didn't have enough population to abide by their own rules, so they had to start marrying outside their tribe, become exogamous. And so by the time white people arrived, you had actually a lot more intermarriage between the tribes, between neighboring tribes than had probably existed in pre-contact times. It was probably there was probably not a whole lot of interference with the Wenatchis' way of life between the 1850s and about 1875. But there had been some gold strikes in the Fraser and other places to the north in what is now Canada. And there were miners and prospectors that went up the Columbia and then onto the Okanagan River and on up into Canada. And this created some violent hostilities that involved the Yakima. And as I said, sometimes the Wenatchee, believing that they had what they regarded as a pretty good deal with the United States, protected white people from the Yakima. So there was some conflict between the Yakima and the Wenatchee in that period, and there may have been conflict in pre-contact times, although we don't really know that for sure. They do speak a different language, of course. The Wenatchee, the Psquosa, speak a dialect of interior Salish, and the Yakima speak another language altogether, a different family group. So the thing that really brought home the problem was probably the railroad. A lot of people started moving there started to be pressure on the area in the 1870s and 1880s, but when the Great Northern Railroad began to push its way through the area, that put a great deal of pressure on the Wenatchis, on the Psquosa, and it also alerted to the United States that they had not done what they needed to do. They'd not ever set up this reservation. So as the Great Northern was unlike the Union Pacific and some of the other huge railroads, operations. James J. Hill, who was the founder of the Great Northern, had determined that he believed he could build this railroad across the continent from St. Paul all the way to Seattle without a big government grant, and that the free market enterprise system would allow him to go faster than the Union Pacific, which was aiming for Portland. And he decided to go over what is now Stevens Pass. Stevens Pass, by the way, is named for the Great Northern's engineer. That is not the one that ran trains, but somebody that was doing surveying, in charge of surveying, and not for Governor Stevens. So when they started coming across here, they had a process with the Secretary of Interior where they were granted a right of way, and they could have various stops, and those stops became towns like the town of Wenatchee. And they made a great deal of money in real estate, buying up cheap lands where they knew they were going to go and nobody else knew they were going to go, and then selling them, doing a real estate development and selling the lands at a high profit. But they determined rather quickly that their railroad was going to go right through what should have been the Wenatchee reservation. So the United States contacted the agent to the Yakima on the Yakima reservation, a guy by the name of Irwin, and told him to see that a reservation was surveyed for the Psquosa that didn't conflict with the railroad. And so Irwin knew exactly where the reservation was supposed to be, and the Psquosa leaders, especially a fellow by the name of John Harmelt, who was the chief of the Psquosa, told them our reservation is supposed to be at the forks of the Icicle and the Wenatchee River. Well, Irwin, who probably worked for the railroad on the side, got the surveyor to survey a reservation clear up near Lake Wenatchee, up in the mountains, where the people couldn't live at that time because the winters were too tough and they wouldn't have had adequate food. So the Psquosa rejected that reservation and said they wouldn't take it. And as a result, the Indian Office, the Commissioner of Indian Affairs in Washington, D.C., told the agent Irwin, well, we need to if they're not going to take that reservation, we need to have them seed it, sell it, and we'll pay them for it, and then we've got this whole problem solved. Well, Irwin consulted with the Psquosa, with the Wenatchee people, and they said, no, it's not our reservation. It's not where our reservation was supposed to be, and it's not ours, so we won't sell it. So Irwin determined, well, heck, I can go to the Yakima and have them sell it, because it was the Yakima Treaty was their treaty, and Article 10 was just part of their treaty. So if we can get them to sell it, then we'll be okay. And in the meantime, he lied to everybody about what he was doing. He lied to the Commissioner of Indian Affairs. He lied to the Psquosa. He lied to the Yakima. But he probably made things a lot easier for the Great Northern Railroad. What he did was he held a council on the Yakima reservation and got the Yakima together and told them, well, the Psquosa won't sell that reservation, so you might as well sell it, and somebody can get the money, so you can get the money. And I think it was something like $20,000, which was a lot more money in the 1890s than it is today. And the Yakima leaders again said, well, it's really not our reservation, it's the Wenatchis. It's, as they called them, it's the Wenatchis reservation. And so we won't do that unless they agree, or unless you agree to give them everything that they were supposed to get under the 1855 treaty. And this exchange was part of the notes that were taken by a scribe who was working for the government. And so when the United States eventually ratified this 1894 agreement, they ratified also a promise to the Psquosa that all of their rights that had been guaranteed them under the 1855 treaty would also be guaranteed them under the 1894 agreement. The Yakimas did agree to sell the Wenatchis reservation, and they received payment for it, and the United States took the payment and applied it to a so-called irrigation unit, where I think the ditches ended up supposedly delivering water at a location that was higher from the source than the source of the water. So the irrigation ditches didn't work, but that was what was done with that money. So with that, they figured they had taken care of the Psquosa once and for all. They didn't have to give them a in the United States over a period 1900s, removed the Wenatchis, the Psquosa, to the Colville Reservation. And so, and let's see, I'm going to show you some slides now. So this is a typical mat lodge. This is the 1880s. So this would have been about the time, this would have been before the time of the railroad. Here is another mat lodge. You can see skins being used, being dried there and used for a door. The Psquosa did have the opportunity to get some allotments. The agent, Irwin, who had said they would get everything they were supposed to get under the 1855 treaty, he never actually gave out allotments equal to the 20,000 acres they'd been promised under the original agreement. And so some Indians took advantage of what was called the Indian Homestead Law. Indians were allowed to make small homesteads. And this is a picture of of John Harmelt and two other men as they were filing Indian homesteads. Unfortunately, the Chelan County judge essentially defrauded all of the Indians in the Wenatchee drainage of their Indian homesteads. And it was the Justice Department eventually found him guilty, but they never received any payment for what they had for their allotments for their homesteads, and they never got any of the land back. They were all removed to the Colville Reservation.
Richard, we have a question from the audience from Walker, and Walker's asking, was the relocation to the Colville Reservation forced?
There were two acts of Congress, yes, over a period of about 20 years. They were forced to move there, yes. I've never read anything that said it was gunpoint, but their lands were taken away from them in the Wenatchee drainage, and they were offered allotments on the Colville Reservation. They settled in one area of the Colville Reservation, and eventually there was an intermarriage and they spread out quite a bit, but they still are kind of focused in that one area on the reservation. Yes, it was a forced relocation. This is another mat lodge. Now, some of the lodges, unlike teepees, unlike our idea of teepees, were extended. You can see this was longer than a teepee. You get the point up here and then a point up there. So you sometimes had multiple families or very extended families in one lodge. This is a great picture because over here is a mat lodge. This is a transition picture I mentioned earlier. And over here you have a canvas lodge. So you can see, but it still has a mat door. And there are hides drying there. And this is from this is right about the period when the railroad was coming through there. These are tules. This is what the mat lodges were made out of. This is about 1900. This is actually, I think, taken on the Colville Reservation. And this is after the people. Oh, this is one of the Indian allotments that was actually in the Wenatchee Valley, and this is before he lost it to the judge. So the Wenatchis became quite poor. There were a handful, including Chief Harmelt, who managed to stay in the Wenatchee drainage. He had a small allotment, a small homestead of land up near Cashmere, on the other side of the road up a canyon from Cashmere. And the leaders, he was the chief. He was the last, oftentimes called the last chief of the Wenatchee or the Psquosa. And they continued to press the United States on the issue of their reservation and their hunting and fishing rights, especially their fishing rights. The Yakima, the signers of the Yakima Treaty, had usual and custom rights, were given usual and custom rights at the fishery just below today's hatchery. But the Wenatchis were denied the right to fish there, even though that had been their fishery traditionally. The Wenatchee, the Psquosa, especially John Harmelt and a couple of other families, the Atkin family and the Harmelt family, pushed and pushed and pushed for their treaty rights, especially their fishing rights. Finally, in 1930, I think it was 1934, Harmelt's home caught fire on the 4th of July, and he and his wife were killed in the fire. This is a picture of a Psquosa man fishing, and this is Tumwater Canyon. And I should just say that briefly, when they were fishing at the Wenatchee fishery at the forks of the Icicle and the Wenatchee River, if you could have gone back there and looked at it, you would have seen weirs, that is, sort of fences built across the river. And fishermen would be out in the water harvesting the fish, and other people, women mainly, would be on the banks smoking the fish and processing them and storing them for winter use. And they would take in many, many tons of fish. The Wenatchee fishery is regarded as having been probably the third largest fishery on the Columbia River system. And so it provided food for a great number of people, all of the Psquosa and a lot of neighboring tribes as well. This is John Harmelt on the right with his family. And this is in 1907s. This is on the Colville Reservation, some of the Wenatchis after they'd moved there. And here is John Harmelt again before his death, about 1930. In the 1930s, Harmelt said, well, what we need to do is hire an attorney and really go to court in Washington, D.C. and prove that we had fishing rights under the 1855 treaty as well as the 1894 agreement. And they had what they called a grand powwow. And it was in the Kashmir area. And this is a picture of that. This is this was on Felix's land. This is before he lost it. They had demonstrations at the time showing, this is John Harmelt in his later years before he was killed. At the grand powwow, interestingly, although they had support from most of the local leaders in the area, and the governor even attended, but the Secretary of Interior would not sign. At the time, a tribe could not hire an attorney without the approval of the Secretary of the Interior, and the Secretary of the Interior and the Commissioner of Indian Affairs refused to allow the Wenatchis to hire an attorney. They had a pretty good attorney who understood the case and drafted a pretty good argument to go to court with. But when they were denied the right to have an attorney, that stopped that effort at that time. Nevertheless, the people continued to take care of their local cemetery, which is still there opposite Kashmir. And they still visited the area to gain materials for baskets and cradle boards and other things that they did traditionally. But it was, and this, they had until relatively recently, in the late 20th century and early 21st century, they had a powwow at Monitor Park. And eventually they were they were told they could no longer do that. And finally, I was hired by the tribe, I believe in the 1990s, about 1996, I think. I was hired in 1996. And in the meantime, you probably all have heard of the Bolt decision. The Bolt decision was the fishing rights case where all of the reservation tribes, the treaty tribes in the interior Washington and interior Oregon, went to court and demanded that they have the usual and accustomed fishing rights that were promised them under the 1855 treaty. The Colville tribe attempted to intervene in that case and apparently didn't really understand the difference between a confederated tribe and the Yakima Nation. And so let me just stop for a second and explain that. So the Yakima, all of the tribes, all the people that became part of the Yakima reservation became part of the Yakima Nation. And the independent tribes that they had been ceased to exist. However, how it worked was that if one of the members of any of the formerly constituent tribes had usual and accustomed fishing places, those rights extended to all the members of the tribe under the Bolt decision. Now at Colville, you didn't have a nation under US law. Instead, you had a confederation of 12 different tribes. So theoretically, each tribe could have separate rights, but rights didn't go to all the rest of the people. So if one tribe had certain rights, those rights were not extended to all the other 11 tribes as they would have been on the Yakima reservation. So the Colvilles, and I'm not an attorney, but I'm a historian, seemed to me that when they tried to intervene in the US v. In the Bolt decision case, US v. Washington, uh, they argued they used an argument that was fallacious. In other words, they tried to say that all members of the Colville tribe, the Confederated Colville tribes, should have usual and custom fishing rights, and the court ruled against them. And so, by the time I was hired in 1996, the court had ruled that the Wenatchis still didn't have any fishing rights or hunting rights in their Aboriginal territory. So what I said was, well, that's not taking into consideration the 1894 agreement, which was also ratified by Congress. You can forget the 1855 treaty because the 1894 agreement promised them all the same rights and also promised them a reservation. So we finally got into court. It took years and years. The trial took place in 2008, and the judge ruled in favor of the Wenatchee. It was very interesting. By that time, it's interesting to look at what happened because the state withdrew its opposition to the Wenatchis, to the Psquosa, and the federal government also withdrew its opposition to the Psquosa. So you have to wonder, well, why did we have to have a trial? That was very expensive, by the way. It's because the Yakima objected to the Wenatchis having any fishing rights. And so I think I should point out that from the point of view of the treaty tribes, that is the tribes that were at Yakima and other treaty reservations who had usual and custom fishing rights, from their perspective, they didn't want to allow any other tribes into that group. They thought it had been set by law, and there shouldn't be any more tribes that were getting usual and custom fishing rights because that might reduce the number of salmon that the existing treaty rights people could get in their fishing activities. But it was at the trial, there were a lot of Yakima people who were in the audience, in the gallery, and a lot of Psquosa people who were in the gallery. It was interesting to me that although the attorneys for the two tribes were at each other's throats, that the people in the audience, the Yakimas and the Psquosa, were getting along just fine. So they were back there, in fact, doing trades, selling fish or trading for fish and talking about who was fishing where. And in all those years, from 1855 all the way to the 2010 decision, Psquosa people had continued to fish in the area that was the Wenatchee fishery. And so when the court finally ruled that the Psquosa did have fishing rights there, there were already people fishing there. So the Ninth Circuit agreed in 2010 with the Psquosa argument, and the Yakima didn't appeal to the Supreme Court. So today, the Psquosa do have fishing rights at the Leavenworth fishery, the fishery below the hatchery. And in addition, of course, I should mention that that agreement also promised the Psquosa that they would have hunting rights and gathering rights, and also should have this So, former administration now, as I've noted, about getting some kind of a reservation for the Psquosa under the 1894 agreement and the 1855 treaty. And what the Forest Service said, and I was at meetings where we I was at a number of meetings where this was discussed. The Forest Service said that they could find 20,000 acres of contiguous, unencumbered land within the National Forest area that was also within Wenatchee Aboriginal Territory. Over the last 4 years, the partisan position of both parties made any kind of an agreement impossible. So I'm hopeful that the new administration, there will be renewed discussions of whether or not that right can be fulfilled, because just like the fishing rights, they were promised trust land, that is reservation land within their Aboriginal territory. And I should add that they have made it very clear that they do not want to take any private property owner's land. They wouldn't be interested in that. They're only talking about land that might be public land that is owned by the United States, and that any existing rights of non-Indians would be maintained. So if they're hunting, fishing, hiking, any kind of access rights that are available today, none of those would be affected. So that's where it stands today. We're very hopeful that that Congress can be less partisan. 25 years ago, I worked on legislation where you could go up and talk to either a Republican or Democrat, and then you could finally work out a system to get something passed. And that is no longer possible. It has not been possible in the last 4 years. If the Republicans were in favor of something, the Democrats would be opposed. And if the Democrats were in favor of it, the Republicans would be opposed. So we'll hope that changes in the future.
Richard, there are a few questions, if you're ready for me to ask you some.
Yeah.
Okay, so there are a couple questions about recommended books, either that you have written or articles you have written, or just books you recommend for additional reading on this topic and on the Psquosa people.
Well, I think that Richard Showerman has written a couple of books, Guardians of the Valley, which he did, I think, 30 or 40 years ago, which is, I know it's available at the library. It's kind of hard to find a used copy to buy even. And then he did an update that the Wenatchee Valley Museum published a few years ago, which is also about the Wenatchee people, and I've forgotten the two best books. So Richard Showerman, if you look up Showerman, Scheurman, and he taught in the Wenatchee area for quite a while, and also he had a very interesting educational project that I think the Bullitt Foundation funded. So those are two. The main thing that I have published was an article in Western Legal History, which is a journal, and it tells the whole history of this claim. It's a little more detailed and not popularly written at all. And if I think can I give my email address out? If I've not answered something, you can email me and I'll try and give you an answer. My email address is e.richard.hart, Hart, @gmail.com. Jean Joseph. Hi, Jean.
Okay, and then we have a question about if folks can get a copy of the map that you showed.
Well, if they email me, I can print out a copy and send them a digital copy of what I've got. It's pretty hard to find. One of the Yakima, again, it's really interesting that the Yakima people actually supported all of the Wenatchee, the Psquosa rights at all of the early councils and meetings with the United States. And then the Yakima opposed the Wenatchee, the Psquosa, when we got to trial. So the position has changed a lot. And I hope that relations between the two tribes get better in the future. But yeah, if you want a copy of that, just email me and I will, I'll get it to you. I see Rachel's posted my email address.
Yeah, and I'll put it on the, are you okay with me putting it on the Facebook for folks who are watching there?
Sure.
Okay. Okay, let's see what other questions. I know it's 1 o'clock, so if folks, need to leave, of course you're allowed, and we'll be respectful of your time. But there's a few other questions. Some of them are talking about reservations and broken treaties. So one question is there precedent in Washington or other parts of the US of addressing broken treaties and reallocating land to fulfill the original agreements? And do you see this possibility for the Psquosa Reservation?
I'm unaware of any situation for any tribe anywhere in the United States that had a ratified treaty and a ratified agreement. So Congress had ratified twice a promise to the tribe for a reservation. So I think that's unique. That's not something where you would find a precedent anywhere. And I don't think it would provide a precedent for any other tribe by meeting the obligation. So from the terms of the Psquosa, meeting this obligation is not something that should affect reservations elsewhere. On the other hand, NARF, the Native American Rights Fund, and other non-government agencies have helped tribes over the years fight for their rights under treaty obligations. And there have been many, many cases. And a lot of cases, the Bolt decision, of course, was a case where many tribes received rights that were promised under a treaty that had not been provided to them. So I think there are a lot of precedents to show that the federal courts have indeed recognized treaty rights after the fact, sometimes long after the fact. And there are many precedents for that. I hope that answers the question. I should add that I worked for the Justice Department. The Justice Department, the United States is in an unusual situation where it has to represent tribes on matters of real property, land or water or reservation boundaries. Under the Constitution, it has to provide that legal representation. And so, and I worked for the Justice Department on Indian cases I represent in a number of cases over a period of about 30 years. And I just wanted to mention that I went before judges that were appointed by Republicans and judges that were appointed by Democrats. And I think universally, all of the judges that I dealt with in the federal system were very able and objective and willing to look at the case law and reach good decisions. That's my experience.
Great. And Richard, I wanted to read you a comment that Nicole put on Facebook, and she would like to thank you. She says, "Thank you, Richard Hart, for the tireless work you've done documenting and translating our history to the wider society. Your assistance securing fishing rights has been invaluable, and our people will not soon forget it."
Well, that's very nice. Thank you.
Mm-hmm. And you're getting lots of thank yous in the chats. Okay, so there's another question about clarification on the topic of the Yakimas selling the Lake Wenatchee Reservation, but retaining confluence land at the Icicle. So I think they just want clarification on that topic.
So they're kind of apples and oranges. What what happened was the cession of the Lake Wenatchee reservation was a council with the Yakima Indians, and the Yakimas took payment for that, just for that reservation, not for anything else. And they took payment for that, and then the United States allocated that payment to a failed irrigation system. So that's separate from their usual and custom fishing rights. Some of the tribes who became part of the Yakima Nation did fish in the Wenatchee fishery area. And so they ended up with, the whole tribe ended up with usual and custom fishing rights there. So those are two separate issues. They're not connected really. So the Yakimas do and should continue to have usual and custom rights to fish where they fish. The cession of the Lake Wenatchee reservation really has nothing to do with that. I hope that, does that explain it to you?
That explains it to me. And if it doesn't explain it for the person who asked, just let us know.
They can always email me, yeah.
Yeah, and then there was a question, and I'm sure others have this too. What can I do to help?
I think the first thing people have said to me is they want to be welcome in their Aboriginal territories. So when they feel like they're being locked out, uh, or when they feel like they're not welcome, especially that's very hurtful to them. I know there are places in the Wenatchee drainage where they dig camas, where they would dig camas, and where they have been prevented from digging camas. They like to collect various materials for basketry. I know that western red cedar roots, sometimes they will cut strips from the roots. And I know I've been out with people where they keep track of which trees they've used so they don't hurt a tree. And I was with one woman one time, and she was able to point out which trees she'd used. She could only use the tree once, and which trees her mother had used and which trees her grandmother had used. So there are a lot of these kinds of things. The first thing is to make people feel welcome. The second thing is to be aware when and if and when we ever get the negotiations going again for a reservation, uh, the support of the community would be great. They've also pointed out in a number of public meetings that we've had that the objective was not to establish a casino anywhere in the valley. But all of those things can be handled in negotiations. And I did also want to point out, if there's one, you could write letters to your congresspeople, your senators. Senator Murray is aware of this situation, and she has expressed support in the past for the Psquosa people and worked pretty hard for us in the past. I hope that something can happen with the new nonpartisan efforts.
Well, thank you, Richard, so much for taking time today to, like Lynn or Nicole said, sharing this information about the Psquosa people. I think there's a lot of new information people learned today, which helps us connect with this place and the ancestral, or the folks who call this their ancestral homelands. And I think another big point I would like to say too is the Psquosa people are still a people. They're not extinct. They're still here. And like Richard said, making them feel welcome when they are in this place is very important. Were you gonna say something? Yeah, thank you so much. And thank you to everybody who tuned in today. This is being recorded and will be available. Any other people who would be interested to see this presentation by Richard and were not able to tune in today live, it's available for them to watch, and please send it out to all the people you know. And thank you again, everybody, and Richard.
Thank you, Rachel, and thank you to the Wenatchee River Institute.
Yes. Yeah. Thanks, everybody.